Subscribe to our YouTube channel and press the bell icon to get the latest updates.
I'm with Arun Shourie, noted journalist, former Indian Express editor, and since then a voice of India. He speaks for several of us. Mr. Shourie, welcome to The Print.
Thank you.
Your latest comments on the Prashant Bhushan contempt case. The Supreme Court had judged him guilty of contempt this week. It's been a busy week with the Supreme Court judging him guilty. Prashant Bhushan refusing to apologize, says he's not guilty. What are your first comments on this matter?
I certainly feel that the Supreme Court has overreached its whatever is good for it. They have, after all, stated their position in 108 pages. They should leave it at that and wait for the vindication by time. To go after a person is only to harm yourself. And
why do you think they're going after him?
But they've painted themselves into a corner with such big words and sentences and pillar of democracy shaken and so on. Nothing like that. The democracy's pillar is being eroded, but by termites within. Nobody is shaking it from outside.
Right. But sir, let me play devil's advocate and ask you, Prashant Bhushan had two tweets in June, one of them where he accused the Supreme Court, in a sense, of going along with an undeclared emergency in our country. And the second one was about Chief Justice Bobde riding this very fancy, lovely Harley Davidson bike in Nagpur. Now, surely, do you think that this warrants contempt? Is this freedom of the speech? Or is this an assault on the judiciary?
No, but how does it, firstly, as you know, in contempt, after 2006, truth is a defense. Mm-hmm. So even if you feel that somebody is assaulting the honor of the Supreme Court and you haul him up, the first thing that you are obliged to do, it's not a gesture of generosity. It is your obligation under the law as Supreme Court judges or High Court judges to give the person the opportunity to prove his assertion. That's the law. How did they not give him the opportunity? Second thing is that as far as aiding and abetting the assault on democracy, there is no doubt that they have done so.
In what way? In what way?
For instance, in the simplest criterion we can take is the cases which they have ignored and the cases which they have taken up. Mm-hmm. See the big the judgments that they have given on habeas corpus. After all, that is the first thing. If my body is not being found, then Anita, my wife, files a habeas corpus. Produce the body.
Right.
That's the basic right.
Yeah.
And habeas corpus petitions from the patriots of the first order on their behalf, like Dr. Farooq Abdullah and others, they've been languishing in the courts. So why did the court not take it up?
What do you think? Why do you think the court is not taking it up?
No, because it is in league with, it is aiding and abetting whatever the executive is doing. And what the executive is doing is undercutting the entire edifice of democratic norms and governance. Mm-hmm. Similarly, if 128 people are killed in false encounters in UP and the court does nothing, mm-hmm. Suo moto, they are going to look at some actor's suicide or murder. They have time for that. Mm-hmm. They have time for some TV anchor that some FIR should or should not be filed against him. But they don't have time for Farooq Abdullah or for the entire population of the valley. Mm-hmm. And they give epileptic orders in regard to Assam on CAA and citizenship. And that alienates an entire population, part of a very sensitive part of our country. Mm-hmm. Or the undermining of elections through electoral bonds. It was clearly a device by which the money will be exacted from corporate houses for the ruling party and nobody else will get it. And the figures showed that.
So you would agree with Prashant Bhushan?
Okay. No, you just see this the latest judgment they've given last week on this PM Cares.
The PM Cares Fund, yes.
They say it's not a government fund. So government, we will not reveal any information about it. हमारे बाप का पैसा है, अरे बाप का पैसे का भी वो देना पड़ता है अकाउंट. अच्छा, you don't give that. Now the Supreme Court says no, it is a trust, therefore it cannot be subject to the CAG. And as I have suggested, now supposing, so there is this fund and 2,700 crores have come from public sector enterprises.
Right.
You think they give it out to the largest of their heart? All right, they have given it, you have it, you are controlled, you know that you will not be asked for it, government rules do not apply, CAG will not audit it, and suddenly there are elections in Bihar and Bengal.
Yeah.
And you suddenly develop such a compassionate heart for victims of floods there, or victims of typhoon, or
but that's a good thing. That's a good thing too.
Why not in the rest of the country? By doing that good thing only in selected areas at selected times, you are perverting the electoral process. And
but how is the judiciary culpable?
Because of their judgment. The judgment said, yes, there shall be no auditing, and yes, it shall not be merged into the PM's relief fund. There is a PM's relief fund. Why do you need a separate cupboard of yours into which nobody else can look?
Right.
So these are the ways in which the Supreme Court has certainly, on its step after step, by omissions and commissions, they have helped, not undermine, but they have assisted in the assault on democratic institutions.
But you would agree then with Prashant Bhushan that, when historians write this period in our history, they will go back and find that the Supreme Court was part of this undeclared emergency, in a sense.
Yes, why wait for historians when we write today? We don't have to wait for history. It is written in front of us today.
Mr. Shourie, you remember the emergency very well, 1975 by Mrs. Indira Gandhi.
Yes.
How would you compare that with a lot of allegations and assertions by people, including Prashant Bhushan, that we are in a state of an undeclared emergency?
Well, I used that phrase several years ago, and it is a much more insidious thing. See, there is no 42nd Amendment, as Mrs. Gandhi had tried to do with the Swaran Singh Committee report, which was to change some aspects of the Constitution. Here, nothing is changed, okay? Everything is just made lifeless and irrelevant. You don't need a new law to saying my supporters or bhakts will have the freedom to take the law into their own hands. You are not passing a new law. You are just establishing that new norm by letting lynchings go on. And it is orchestrated. Because just see how they started and how they immediately finished. How? The condition of cows has improved so much, is it? Overnight. And what did the Supreme Court do on that? Is there a single case in which they intervened? This whole business, suo moto. You take notice of things which are trivial on your own. And the gravest things that are being done to change public discourse in India, to change public norms in India, to undermine institutions, you don't look at them. So aren't you culpable?
So may I bring you back to the Prashant Bhushan case, in which he says the judges have now said that by the 24th of August, which is by Monday, he should reconsider his tweets, the 2 tweets that he gave in June, and that if he apologizes, then they will let him off the hook. Prashant Bhushan says that he's not going to ask for mercy, that he's not asking for any magnanimity, and that the tweets express what he says and continue to be his bona fide belief. So my question to you is, that the judge has noted that freedom of speech is not absolute to anyone. What do you make of that?
But that's the Constitution. After all, restrictions are placed under Article 19(1)(2).
Yeah.
So nobody who is claiming absolute freedom of speech. I am not saying here that I have the freedom to abuse you, to tarnish your image, to attack your children. No, I'm not saying that. I'm expressing a view regarding the functioning of a public institution. And your obligation as a judge is to give me the opportunity to prove in open court before you the facts which have led me to that conclusion.
So the fact that the judges are not allowing him to do that, what do you make of it?
Well, that is a violation of the law.
What does it do to our democracy? Does it impact on freedom of speech like yours? And,
yes, no doubt.
Does it deter us?
Yes, it has what the Supreme Court calls a chilling effect. So that is terrible. And all the more so, you see, chilling effect in this law of contempt comes even if it is a civil offense. Because there are hardly any media houses today which will risk heavy fines and thereby give reporters or anchors or writers or columnists the full freedom to talk about the judiciary. But when it is a criminal offense, then naturally they are even more reticent.
Yeah.
So it has a chilling effect, and then that infirmity in the law of continuing to treat this as a criminal offense, an obsolete provision of the British period, which has been given up even in Britain, forget other places. But when you compound that by an erratic administration of that clause, erratic application of that clause, then naturally the chilling effect is much greater, because people, to the law, which is onerous enough, you are now adding an element of uncertainty. Pata nahi hai judge kya kar de. So it certainly has an effect on the freedom of speech, but I feel that it has an even greater effect on the reputation of the court.
In what way?
It's not Prashant Bhushan and his little tweets which are affecting the reputation of the court. It is the last 7-8 pages of the Supreme Court's own judgment. They are saying, we are so weak now, we are so weak, that 2 little tweets are shaking the central pillar of democracy. That who said that? Prashant Bhushan said it? Jyoti Malhotra said it? I said it? No. Supreme Court 3 judges said it. So next time when you have to go, you are in a problem, I'm in a problem, and I say कि Supreme Court के पास चलना चाहिए. वो कहते हैं यार वो खुद कह रहे हैं कि वो बेचारे निहत्थे हो गए हैं, कमजोर हो गए हैं, उनके पास जाने से क्या फायदा है? Who has brought me to that conclusion? Not Prashant, not any columnist, but the Supreme Court judges. So I think that it is not just that they are undermining freedom of speech and asserting and sort of setting a straw man, as if somebody has said that the right to free speech is absolute. Nobody has said it. That is how it was when the Constitution was passed.
Right.
But in the Ramesh Thapar case, in Searchlight and others, in the First Amendment, then Article 19(2) was introduced and restrictions were placed on the freedom of speech. And for 70 years, everybody has accepted that, yes, I will work within those parameters. Who is saying it is absolute?
So last couple of questions, Mr. Shourie. One is that as ordinary citizens, I think we were amazed that the Chief Justice, when he sat on that really beautiful motorcycle, the Harley Davidson, it was quite a lovely picture, wasn't it? But for the Supreme Court to take, to take objection to somebody's comment on that, it was just a very ordinary and a simple comment. I think that also worried us a bit, that they would be upset about something as inoffensive as that.
Actually, if I were a colleague of the Chief Justice, I don't want to repeat myself on this, I would have advised him not to sit on a bike that costs 50 lakhs, which he cannot afford, which belongs to the son of or to the person who is connected with the ruling party.
It was a lark. It was a lark, Mr. Shourie. I'm sure he doesn't own a bike.
But you see, I feel that you can't, when you are sitting in such a high position, you cannot go on for larks. Because everything you do, you glance in a particular way at a litigant, that has a very far-reaching effect. There is no difference between going in for private larks and your public duties. Because what you do privately sends out a signal to others, to your colleagues, to the junior. If the Chief Justice can sit on a 50 lakh motorbike, I am a magistrate, why can't I sit on Jyoti Malhotra's son's bike of 10 lakhs? What is the problem?
Well, I don't have a son, Mr. Shourie, but my last question.
and not a 10 lakh motorcycle either.
Exactly.
Yes, but that is the signal that will be given.
Yeah.
And
yeah, no, I was just saying that my last question.
For instance, I'll tell you why. Why do judges not, I mean, I've known some of India's best judges firsthand. Justice Krishna Iyer, I knew personally. Justice Tulsapurkar, I knew personally. You try and call them for a dinner at your house and they will not come. Because distance.
Right.
And it was a very restricted circle of their own colleagues in which they will move. And to imagine them sitting on Harley Davidson or whatever the motorcycles are, unimaginable.
Which leads me to the last question, which is about sinecures, post-retirement sinecures for judges. You know, the former Chief Justice of India has just been made a Rajya Sabha MP. What do you make of that?
Well, and he has been made a Rajya Sabha MP after a series of judgments which by coincidence happened to be so convenient to the government.
Well, perhaps that's the law. That's a judgment. Those are the judgments he's made. I mean, we can't question him on that.
Why not? Who is he? And what are those judgments? The 10 Commandments? Even the 10 Commandments in the Bible are questioned. Upanishads are questioned. It is our right and our duty to analyze and question judgments. As for the person, the judge, certainly in his conduct, before or after or during his chief justiceship, it's a public office, and all of us have the right to do it and our duty to question it. Because, and actually I have been feeling for a long time that this is one of the ways in which the judiciary has been suborned. It is one of the easiest ways for the government. Hold out a carrot, hold out a little pear, you will become the head of the national, what the lawyers call a very heavy assignment. You know what a heavy assignment is? In which a lot of money is involved.
Right.
In which you will be deciding cases in which a lot of money goes here or there. To this corporate house or to that corporate house, or in its tax liabilities to the government, or it keeps it by itself. So, National Company Law Board or Tribunal. And somebody holds that prospect out to you, not directly, but to the fifth person. Vacancy aa rahi hai. And it just so happens that you tend to find great merit in positions that are convenient to the government. And after that, you take that particular post. Will people not put that together? I feel under the Prevention of Corruption Act, forget public discourse, under the Prevention of Corruption Act, accepting sinecures like this is an act of corruption. Because the Prevention of Corruption Act does not define corruption merely in terms of what they call, something monetary, that is not just money changing hands, it is any favor. And certainly any advantage. And this is certainly an advantage that you are taking and somebody is giving to you. Who is giving it? The biggest litigant before you.
The government.
Government of India is the biggest litigant in India.
Right.
You give a series of judgments. Those turn out to be convenient to the government by your conscience and reasoning. And that biggest litigant then gives you a sinecure, a dead body like the press council, another dead body that has been killed, another the sort of carcass of another cow, the Human Rights Commission, or a lucrative place like the National Tribunal on this company law business. So, who is not? That is certainly an advantage, and it has been given to you by the litigant who is appearing before you time and again. In fact, more than any other litigant.
Knowing you, Mr. Shourie, you're obviously signaling towards something on the company law board example. But as always, wonderful to talk to you. Thank you so much for your time. I know you're a really busy man. But journalist to journalist, it's always a pleasure. And thank you so much for speaking to the
Thank you very much. Thank you.
Thank you, sir. Thanks so much.